Hello and welcome to Law 2023 Online Commercial Property Spring Shape the Debate with me, Mark Shelton, and Richard Snape.
Hello.
Today's Q&A is going to last 1 hour, and we're going to cover your pre-submitted questions. So just a few introductions. Two introductions first, just for the two of us. First of all, introduce myself. As I say, I'm Mark Shelton. I've worked in major commercial law firms for 29 years as a property litigator. I've acted for a range of clients from FTSE 100 investment companies and major corporate occupiers through to small businesses and individuals. And I'm an expert in commercial property management law, as well as advising on the structuring and documentation of transactions. I've conducted a wide range of commercial property disputes, acting both for landlords and for tenants. Now I'm a non-practicing solicitor, and I work as a commercial property management law trainer, putting my expertise and experience to, I hope, good use in training both lawyers and surveyors. And as part of Law 2023 Online Commercial Property, my sessions include contracting leases out of the 1954 Act, practical approach to the 6 question marks, and regularising informal occupation. Richard has been the head of professional support at Davitt Jones Bold since 2002. He speaks at numerous courses for law societies all over the country, various public courses, in-house seminars within solicitors' firms, and has also talked extensively to local authorities and central government bodies. His areas of specialism include both commercial and residential property, in particular in relation to local government law, conveyancing issues, development land, commercial property, and encumbrances in relation to land. And as part of Law 2023 Online, Richard Snape's sessions include overage clauses and clawback, and the Landlord and Tenant Act 1954, grounds of opposition, renewal terms, and interim rents. So hopefully we've been able to generate a bit of interest, and we have some pre-submitted questions to deal with, and I'll introduce them. Richard, I think the first one is for you, and this one is, what's the best way of securing overage against a subsequent purchaser?
If I could tell you a perfect way of securing overage against subsequent purchases, I probably wouldn't, because I'd first make my fortune with that information. I can tell you some ways are better than others. I suppose, I always think the worst way of sort of answering it that way is restrictive covenants, and you still see that. So, sort of restrictive covenants: you can't build if you get planning permission, give us some extra money. And there are so many reasons I dealt with in my talk not to use those. The best easy way, there are some very esoteric ways of enforcing overage, but if you were to ask me the best easy way, and I suspect the one that people see who are watching this, listening to this, it's deeds of covenants, direct covenants and restrictions. You sort of the problem with sort of overage is it's a positive covenant using a sort of, it's not so much like some restrictive covenants. You can't build, give us some money if you get planning permission and we discharge the covenant. It's more sort of, if you build, you'll give us some extra money. And positive covenants, not property rights and freehold land. If the government wanted to do something useful, they might actually look at making them property rights and freehold land. That's for another day. But you can sort of deal with them by deeds of covenant. You've got a contractual right. I can sell my land to you. We've got a contract between the two of us. And if you sell in that contract, I can require you to make your purchaser enter into a deed of covenant with me, and I'll back it up with a restriction. You can't become registered proprietor without my consent. And I'll give the consent if I get the deed of covenant, and you could go right down a sort of chain like that. If you were to ask me the very best way, if you can get it, and it's a big if, it would be an overage charge. You can back it up with deeds of covenant restrictions as well. But you charge your property to me, and it's a charge like any other charge. But this doesn't get paid until an event occurs, like, for instance, obtaining planning permission or selling an additional property or something. And if you don't pay me the money, plus interest according to the charge and so on, I've got exactly the same remedies as if you don't pay your mortgage. The only problem, it's a very big problem on that, is you have to get people's consent, including other mortgage companies. And other mortgage companies are not going to consent to a charge that's certainly with priority. It's not designed for small disposals. It's designed for large ones. But in the average everyday disposal, it's deeds of covenant restrictions. I don't know if you want to add to that, Mark.
Well, it just going to me as you were speaking. I don't know if you saw. I'm sure you would have done. It was 2 or 3 weeks ago. A case in the upper tribunal called Re Camiade. And there was a lady, Ms. Camiade, who had a restriction on her title preventing registration of a disposition without the consent of a third party, and the third party couldn't be contacted.
Yeah.
And she applied to modify or discharge the restriction. Which, if successful, I suppose, could undermine the deeds of covenant and restrictions sort of way of doing it, but it was unsuccessful for the, I suppose, fairly obvious reason that it wasn't a restriction as to user of the property; it's just a restriction as to disposition of it. So I suppose I think that's a reassuring. If any further reassurance is needed, but yeah, I think that's always been my understanding. Deeds of covenant and restrictions are the best way to go about it.
If I was disposing of an airfield like that for a huge farm, I'd probably want an overage charge as well. Include the deed of covenant and the restriction and the charge. But it's just, you have to be dealing with people who are buying property and developing property need financing elsewhere, and the mortgagees, unless it is something like that, and you've got sophisticated lending, if there is such a thing, are not going to accept that. They're always the whim of the. I remember you're at the whim of the market as well, and who knows what's around the corner. I remember back in 2005, 6, 7, and like pre-credit crunch days, where overage was being used all over the place, frankly, on properties where it shouldn't be used. And then suddenly the market turned for the worse, and even the big time disposals, mortgagees were just saying no to overage charges. It depends on the circumstances to some extent. There's too much overage, Mark.
Too many other people making more money. That's what it is. So right, next question then, and this I think is for me. The Law Commission is going to consult on the workings of the 1954 Act later this year. Yes, they are. Do you think it likely there'll be any change to contracting out? Well, I suppose the answer is hope so. It's up to us to, I guess, take part in the consultation and to get that issue on the agenda. I mean, it's. I remember, that there's so much history with dissatisfaction with the old court-based process, and it was a sort of a relief in 2003 when proposals were put forward for the notice and declaration procedure, which sounded so much more simple. And I remember, at the time, I was a professional support lawyer, and I used to sit in meetings with other professional support lawyers discussing how the new system would work and what the ins and outs might be and what the best practice might be, which was just as fascinating as it sounds. And we ended up, I think, our internal guidance as to dealing with this simple notice and declaration process ran to about 24 pages of A4. It was so many kind of ins and outs, so many implications of it, which just hadn't been thought about in government, and also just idiotic stuff like drafting forms of notice without a space to put the date in or a space to sign it and so forth. I mean, it was a real missed opportunity, I think, at the time to make contracting out much simpler. We don't know. We haven't seen what the consultation process is going to look like. The hints are that there will be an aim to try to produce a much more streamlined and a much more sort of commercial sort of process, certainly for lease renewals, and one would hope for contracting out as well. So I would hope so, but as I say, I think it's for us to take part in the process and put our views in. Do you have any thoughts on that, Richard?
Yeah, I remember when the 54 Act changes all came in 2004, and I was doing courses on it then. As much child lecturer with dark hair then, but I thought the warning notice, they were a bit of a fudge because the original version didn't have the sort of less than 14 days running stat deck and 14 or more days, to the simple declaration. And I'm not sure why they fudged that, because I'm not sure what a stat deck adds to the event. You're not supposed to give advice on a stat deck. And there are so many issues. I'm amazed that I don't know if you're coming up to it. I suspect you might be, but I was amazed it took so long for the courts to deal with things like what the term commencement date is in those notices. They were badly thought out.
Yeah.
Well, we'll have to see what happens. I know the Law Commission have been talking about changes to the 54 Act for many a year. It sort of resurfaces every now and then. But we'll have to see what happens. I mean, one thing you might just consider, it wouldn't be good news for me in courses, but do we really need a 54 Act full stop?
Just exactly what I was thinking. And it's I know the history is, it was introduced in the aftermath of World War II when our cities were full of bomb craters and there was a shortage of commercial property stock. Well, those circumstances no longer apply, and I mean, there's no other developed economy, as far as I know, that has any kind of system, anything like it. Everyone manages perfectly well without it,
including Scotland.
Every now and again, somebody learned writes an article in the States Gazette or somewhere saying, "Isn't it time we repeal the 1954 Act?" It's surprising that government isn't thinking in those terms, really, it seems to me.
It wouldn't make for a very good course, though, would it? It'd be quite a course.
Well, I may as well retire if they repeal the 1954 Act, but there it is.
It's far too much like a game of poker, isn't it, really? It's a sort of battle of wits between the parties. Who gets there first with your Section 25 notice or your Section 26 request?
Well, of course, with the 2003 changes took away a lot of our dirty tricks and tactical games, but there's still plenty. So, yeah. Okay. So next question for you. Do you think that SPS and Mahill is correct? There's a fairly blunt question.
Well, no, I don't. SPS and Mahill, I never know. It's this auction case from about a year ago now, I think. Involving overage as well, whereby basically Mahill, was a established property developer, was given every opportunity to download the auction pack, which had told her that there was 50% overage, high overage, if they got planning permission to build on this field in Leicestershire, and given every opportunity at the day of the auction to look at the pack. And, official copies were in there. There was an overage deed in there. There was a restriction on title. And just ignored it and bid way over the odds and successfully argued that I don't have to go ahead with completion. Because the High Court judge decided, unlike the County Court, that overage was they said it was a defect in title, which I can't for the life of me understand. And you're duty bound to notify defects in title expressly. And it's not enough to have an established property developer be able to, look at the pack that would have fully told them about it. And it just seems absolute nonsense to me. I always remember caveat emptor, and it flies in the face of it. So,
I mean, it's you rather wonder why we've been wasting our time with registration of title over the past 150 years or so. And why bother producing an auction pack, a legal pack? I mean, it is hard to know what on earth extra you're supposed to do. And I think for a solicitor who's acting on an auction sale, how much do you have to hold the auctioneer's hand and make sure that that they've drawn things to the attention of buyers? And because if things go wrong and the sale goes off, well, I suppose the seller is going to be looking to their solicitors and saying, well, why didn't you make sure the auctioneer did things correctly?
Well, apparently what happened, because they Mahill been able to sort of not go ahead with the completion, SPS Groundworks put the property up for auction again, and at the very last moment realised they'd done the same thing and had to contact the auctioneer just before the auction started. And you must notify, the fact that there's this 50% uplift overage, 50% of betterment value if you get planning permission. The strange thing in that case, actually, and I didn't mention this in the conference, is the judge decided that overage was a defect in title. You could also, I mean, if that's the case, what about a restrictive covenant? What about, stopping development? What about a access way across the land that will stop you developing in that part? But they'd also sort of announced that this field had superb opportunities for development and the likes. And it had, the parish council had already successfully objected to planning applications in the area because of the lack of amenity. But the judge decided that wasn't a misrepresentation. That was just, a mere business stuff. And I think the argument that succeeded should have failed, and probably the argument that failed should have succeeded.
Yeah. I mean, I see there's another question on the case. We may as well take it at the same time, which is what should we do in practice about SPS and Mahil?
Well, again, it sort of does depend to some extent. It's not just about auctions. It could be about other things besides, but obviously auctions is an area where the solicitors don't get involved until it's too late. I remember mentioning SPS earlier this year in a course, and somebody told me that they'd got a client turned up to see the solicitor after the auction, having successfully bid on a house, not realizing it was a leasehold house with only 11 years left on the lease. And they spent hundreds of thousands on this property. So auctions is the obvious problem area. I think what conveyancers and solicitors should do is what they finally did in that case in the second auction. You tell the auctioneer to expressly announce, any encumbrances in relation to the property.
But it is, as you say, hard to know where you draw the line and which ones have to be expressly announced and which ones don't.
I've got if they don't see a solicitor if they see a solicitor before they bid at the auction, and the solicitor doesn't point out the overage, the solicitor is at fault.
Yeah,
if they don't bother seeing a solicitor, especially as they're an established, someone who's been doing numerous auctions in the past. As far as I can see, unlike the judge, it's their fault. It's their problem.
Yeah. Yes. Well, we get these decisions from time to time. Now this one is to do with my my session about informal occupation. I think a lot of landlords prefer to grant licenses to avoid the 1954 Act instead of contracting out. Is it your view that that's too risky? Because well covered ground, really, the risks of licenses. I mean, what I was thinking is interesting about the use of licenses for just regulating short periods of occupation, relatively informal situations, is every time a solicitor speaks to an audience of surveyors or speaks to a client, they always bash them over the head and say, "Don't do it; it's too risky," and people keep on doing it. And the reason they keep on doing it is because it doesn't blow up in their face the entire time. Licenses have got their place. And I think with a few kind of common sense measures, it's a useful tool. I mean, one, obviously the risk being, just to sort of recap the obvious, but if the licensee so-called actually has exclusive possession, then they will have a tenancy rather than a license, and because you won't have contracted it out, it'll be within the 1954 Act, and it may be difficult to get them out. So, I mean, one of the things that people do is contract out the license and go through that procedure in relation to the license, which I always think is a bit, if you're going to acknowledge it's a tenancy, then call it a tenancy and contract it out. I mean, what's the difference, In the same way, people may grant 6-month licenses, take advantage of Section 43 of the 1954 Act. So, if it is a tenancy, then it still won't have security of tenure because it's 6 months or less. Again, why not call it a tenancy if you're going to acknowledge that? I mean, that's kind of time limited because you can only do 2 safely without coming up against the rule that once the occupier has 12 months occupation, they come within the Act anyway. But other stuff people do is having a provision in there for the licensor, the property owner, to be able to move the licensee around from one place to another within the property where that's possible. And that obviously negatives any idea of exclusive possession. The courts will have a look and see whether that's a sham, whether it's just trying to pull the wool over everyone's eyes. So if one has that kind of provision, it's a good idea to use it from time to time. But I mean, those are things that people do. But I mean, I say a lot of the time it just causes no problems. A certain element of trust in it, and the serviced office industry works on licenses, and they have their place. But I think one does need to be aware of the kind of measures you can take to make it less risky, and try to use those as much as you can. Anything to add, Richard?
Yeah, it's sort of one of the things I've been asked about, like you say, not so much by the lawyers, but by the surveyors over many years. And it's, it's what you do at your degree level, Street and Mountford. You've got exclusive possession for a term and a rent, unless there's an exceptional circumstance, it's a lease no matter what you call it. Yeah. And I'd work on that basis. I remember having a meeting. It wasn't so much of a course, it was a meeting with sort of investment fund some years ago now. And they were sort of specialising in little lock-up news agents all over the southeast of England, and sort of little cafes and the likes all over the place. They were calling them all licenses, and they were almost certainly all leases. And they did admit to me the reason they called them these 3-year licenses is because they didn't want the expense of employing lawyers to serve the notices, the exclusion notices. And the sad fact is, in the large majority of occasions, they probably get away with it. And their biggest problem with that kind of occupier is not getting rid of them at the end of 3 years, it's keeping them.
Yeah.
I'd always thought if in doubt, contract out. It's my catchphrase, Mark. But I've decided I need a catchphrase. And if in doubt, I'd assume it's a lease and I'd contract out. There are a few exceptions, like caretakers, service occupiers. There's all these guardian schemes that have had case law on them this last couple of years, 2 or 3 years. So there are exceptions, but if I had any doubt whatsoever and I wanted to be sure of getting that property back, I'd just serve the exclusion notices.
Yeah, I mean, I think you can get very sort of academic and esoteric about what exclusive possession is, but I think the rule of thumb is if people lock up at night, they've got exclusive possession, and that's most commercial occupiers. I think shared space in a warehouse maybe, or concession stall in a shopping mall, that kind of thing, you're safe enough. But otherwise the risk is there. I mean, it's interesting what you're saying about people using these documents to avoid the expense of instructing solicitors, and I think that's right. People have always had that view that if you've got a standard form letter license, that's okay, you can do that without using a solicitor, even maybe a standard form short tenancy at will agreement. But if it's a lease and if you're going to contract it out, you've got to pay expensive lawyers. I think that's changing a bit. I think when I speak to surveyors, when I'm doing training sessions, and I think people increasingly are having the confidence to take a standard form lease and use it themselves, and to do the notice and declaration procedure themselves as well. And I don't have any difficulty with that. I think inappropriate cases, that's a reasonably straightforward thing to do, and it's no different from really what people do in the residential letting market. They pull an AST out of the drawer and say sign here, and nobody worries about that process. So I think we may see more of that.
Yeah. I've seen some. Having said that, if it's the sort of lower end of the market, I can understand it. But I've actually come across some disastrous things that have been called licenses over the years and weren't licenses, leases. And they've got 54 Act protection. Sure. They're sort of pretty expensive properties on occasion.
Yeah. Well, I'll take another one for me, which is also, I think, sort of a follow-on question, which is if a tenant's holding over after the term expiry of a lease within the Act, and the tenant then agrees to take a new contracted out lease, does the tenant need to go out of occupation for a short period before the contracted out lease is granted? That's that's something that I've been asked before in practice, and I think there's a kind of fear that when a tenant has security of tenure, that you need to show some kind of break. They need to go out of business occupation to bring that security of tenure to an end before you grant them a new tenancy, which is without security of tenure, which is contracted out to the 1954 Act. I'm never a big fan of little theatrical performances of this sort. I don't think they're very convincing, and I don't see a technical question with it. I'm interested to know if you see any if you have another idea, Richard. But it seems to me, once you have somebody who is in occupation pursuant to a tenancy, and you grant them a new tenancy, then as a matter of law, that's a surrender of the old tenancy with their security of tenure rights, and the new tenancy contracted out is absolutely fine. So I'm not nervous about that at all. Any other views, Richard?
Well, I mean, it's again something I've been asked over the years. I mean, I think there's an analogy with years ago. I used to do a bit of housing law in residential, short-term landlord and tenant. I gave that up a long time ago. And there were always questions when assured short holds weren't automatic. You had to serve notices and the likes. Could you have an assured tenancy and then sort of make it an assured short hold? When the fixed term assureds come to an end. And there are actually cases from the before ASTs in the rent out protected tenancies and protected short holds, which basically said the same thing as you. You don't necessarily have to have a gap. But the one thing I think you do have to have is legal representation. I wouldn't want to do that unless the tenant was legally represented and given the opportunity.
Yeah. Which is often a difficulty. Small businesses very often will not have legal representation when they're negotiating their leases, which of course gives rise to all sorts of problems, not just that one. But,
they don't have surveyors, they don't have valuers, nothing.
No. It all comes home to roost at the end of the lease, but there it is. Okay, so one for you. Very broad on this one. To what extent can a lease be varied in a Landlord and Tenant Act renewal? Have we got half an hour for this one?
Depends on which county court judge you're talking to.
Yeah.
But it depends on which term you're talking about. I mean, because obviously the obvious thing that can be varied is the rent. That's the usual reason for initiating a renewal. To get a market rent, either upwards or downwards. And you can vary, the duration. It's obviously you can vary if the parties, determine. You can always reach an agreement. But I suppose you're talking about Section 35 and any other terms. And basically, the Section 35 of the Landlord and Tenant Act 54 Act says that you're supposed to have regard to the terms of the current tenancy. And probably the most important 54 Act case of all, House of Lords, as they were, case O'May and City of London Real Property Company. I think it was reported in '83, but it was heard a bit earlier. They basically picked up on that, and the House of Lords said that the starting point is, unless the parties agree, the old lease is the basis of the new lease, and anybody who wants to change that has to, the burden is upon them. It's a strong burden, a bit stronger than people might imagine on occasion, and any changes have to be just and equitable between the parties. And the fact that you're offering reduced rent is not necessarily a good reason for varying the terms, but you could go on and on and on. I think the starting point has always got to be, you've got to have regard to the terms of the current tenancy.
Yeah, I mean, I know, and the O'May case was of course where you had the lease which was being renewed had an inclusive rent, no service charge payable, and the landlord wanted to insert a service charge provision. And I've still got a lot of sympathy with what the landlord argued in that case. When they said, well, look, you try to go out in the City of London property market in 1983 and get a lease without a service charge when you're receiving services. It ain't there. You're trying to get something which is better than the market. And the 1954 Act is not there to enable tenants to beat the market. It's to give them security of tenure.
Well, you've wiped off a huge amount of money from the value of the reversion of that property. People are not going to take that on.
Yeah. But I mean, that was the outcome. The tenant got a deal better than the market, and that's kind of the way it works. And I remember actually, it sounds so wishy-washy, doesn't it? The court must have regard to the terms of the old tenancy. It doesn't sound like a kind of hard sort of rule. But I can think of a case where I was acting 15 years ago, and our client was a well-known multiple retailer, and we had a landlord which was a life insurance company who decided to take a slightly sort of hard-nosed approach, and they said, here's our new standard form of lease, you're going to sign it. And our client's retail director was a sort of tough-speaking Yorkshireman who didn't like to take any sort of stuff from anybody. So he said, no, I'm not going to. We're perfectly happy with the lease we've got, which, having been renewed a few times, was in a form that was been granted about 35 years beforehand, and it was a very sort of old-fashioned looking lease. And we went all the way to the doors of the court with that, and the landlord caved at the last minute because they knew that OMA meant that we would get the lease that we started off with.
Yeah.
And it really is quite a hard-edged sort of principle at the end of the day.
Yeah, I mean, people also think you can, you can take into account certainly the old lease remaining in existence would give rise to an absurdity. But you can't automatically assume you can upgrade to modern standards. You see leases that have been through, 5-year lease that's been through 7 or 8, renewals over the years, and it started off like that. It's now like that. And, the tenants could object. Sometimes it's the other way around. Sometimes it might just be the tenants who are wanting changes, which the landlord would be well advised to object to. I've seen tenants suggest, sort of we'll change the user covenants in the lease, make them much more restrictive because we're not going to do anything, besides that. And the landlords, if they agree to that, they'll have all kinds of problems with the rent review.
Yeah.
I think the rent is the other issue. You shouldn't get something for nothing. Again, it depends on people, getting legal representation and valuers to tell you in these things. But if you get a favourable term for yourself in that lease, then it should be reflected in the rental. And I've always sort of assumed to some extent. But what's that Edwards and Wharton case, the Mayor of London, if you remember that from a few years ago, which just flew in the face of OMA.
Because they had a service charge provision in
various different service charge provisions.
Yeah, very, very different factual background though, but it shows again that there's no hard and fast rules. One thing that always interests me is people always say, as a sort of exception to that principle, that you can get away with so-called reasonable updating, which always baffles me. And if a client says, "Oh, surely this is reasonable updating," I kind of don't know where to look, because as far as I know, the words reasonable updating have never passed a judge's lips in a 1954 Act case. I think it's more of a kind of convenient market consensus rather than a sort of legal principle. What's your thought?
Yeah, I agree entirely. I think there's a lot of myths and misconceptions about Section 35. And you remember those two, not so long ago, two post-COVID county court cases? W.H. Smith, was it W.H. Smith's and Commerce, investment Gazelle Shaft, and then there was that Poundland and Top Lane case. They're both county court cases, so not precedents, where one of them accepted the change to the rent suspension provisions. In W.H. Smith's, the penny shop in this big shopping centre, the Westfield Centre, shut, then now rent would be halved for the duration. Whereas in Poundland and Top Lane, the idea of a rent suspension in relation to lockdowns and future mandatory closures was just not accepted.
Yeah.
And the county court judge in Top Lane distinguished it on the basis that in W.H. Smith, the landlord was prepared to accept some change to the rent suspension provisions in relation to the future lockdown, and in Poundland and Top Lane they weren't. So I think the message there is don't accept anything.
Absolutely.
Because if you accept something, you might find that you have to accept a lot more.
Yeah. So the only other short thing to add is that with the Law Commission reviewing the 1954 Act, I mean, there's some sort of talk flying around about standard form leases, or at least template leases, being part of the process. I think that'd be no bad thing, do you? I mean, if you're talking about kind of leases for 5 years or less with no rent review, and it seems to me that's something you could quite easily legislate for.
I think for those sort of, let's say, lower end of the market, short-term leases, I think there's something to be said for it. Obviously, the more you get complicated, I mean, it gets a lot different, but you see some leases which are completely inappropriate. I remember seeing firms relying on their own precedents a bit too much. I came across one with car parking spaces, one single building on it, and the lease had provision that the tenant had to yield up at the end of the lease with new carpets on their car parking spaces. But I think they accepted that probably wasn't acceptable. But yeah, a lot of leases would benefit from being a bit shorter, quite honestly.
Yeah, I think so. Okay, then we'll move on. And this is another one about 54 Act. This one's for me, and it's to do with the contracting out process. I often draft the stat deck so that the term commencement date is stated to be a date to be agreed. Do you agree that's safe? Yes, you sort of hinted we might be talking about this later on, and here's the question. So this is one of the issues in that TFS stores case, with a tenant trying to weasel out of having contracted out 6 leases, I think, with the same landlord. And they tried to argue the process was invalid. One of the reasons being that the form of stat dec requires you to state the term commencement date, and often, of course, you just can't, because it's some date that you don't know yet, or it's dependent upon something that you can't control, like when the landlord gives consent and so forth. So the superior landlord gives consent, and I said, I referred to the sort of meetings I used to sit in where we sort of beat our brains out about this new process and how it would work, and people expressed concerns that in those circumstances, if you couldn't put a date in, it would be an invalid contracting out, exactly as the tenant argued in that case. And I always took the view that the purpose of giving those details, well, that among other details in the stat deck, is to identify the lease that you're talking about. And as long as you're not putting anything which is misleading or points you to a different lease or is inaccurate, then that should be fine. And if you can't specify a date, you have to adopt a form of words which does the best you can. And that is broadly the approach taken by the judge in the TFS stores case. And so, whether you say a date to be inserted at clause X of the lease, or a date to be agreed between the parties, or whatever it may be, I think it's absolutely fine. I've never had a problem with it, and I think in the wake of the TFS stores case, I have even less of a problem with it. So
yeah. I think in TFS they were fishing around desperately for ways of arguing that the leases weren't excluded, because the landlord was granting new leases to their main competitor with a very similar sounding name, the fragrance shop and the perfume shop.
Yeah.
I think that's probably what irked them. And I think, ever since it came in, or ever since it was proposed in 2003, I think it's a mistake, quite honestly. I'm amazed it took so long to get through the courts. It's a shame they didn't get leave to appeal to the Supreme Court on it. But because we could have perhaps decided a few other things besides. But if the judges at High Court, the Court of Appeal, hadn't decided as they did, to be agreed or whatever, I have to wonder how many excluded leases there were out there after they decided otherwise. Not many.
Yeah, absolutely. Okay, we're still on the 1954, I think, with the next question. Don't a large number of leases exclude compensation for disturbance, Richard?
They do.
They do.
That's the answer. I've talked to people about this who don't realise it. You can exclude compensation for disturbance when you're using a non-fault ground, EFG, using demolition, reconstruction, or occupation for your own purposes. If the lease, if you've been in occupation for 5 years or more before the lease came to an end, for the purpose of the 54 Act, then the exclusion of compensation for disturbance is void. And if you can show 14 years occupation before the lease came to an end, you get double compensation. Came to an end for the purpose of the 54 Act, you get twice compensation. Yeah. And it's worth having on occasion. And I suppose the other thing is make sure that if you're entitled to compensation for disturbance, you stay, even if you're not running your business, you can remain in occupation, hand in the keys at the last moment, before the lease comes to an end for the purpose of the Act.
Yeah.
I think
sorry, okay.
Go on out. So.
No, I was going to say, I'm just reminded of that, one of those virtually unpronounceable cases, Bakioki and academic agency. Have you indeed? Right.
It's in Bath, North Parade in Bath.
Okay. Live and learn.
I
There you
used to
go.
live in Bath.
Yeah.
It's an Italian restaurant now. It's Creek, I think.
All right. But I mean, they had that case where they'd been in occupation for I think about 30 years. So they should have had not only compensation for disturbance, but also compensation at the higher level. Um, but moved out 14 days before the end of the term, and because the qualification is that you're supposed to have 5 years occupation immediately prior to the lease coming to an end. And uh, the court really stretched the law to the limit, didn't it? In answering that one and saying that if you're out of occupation for a short period, even at the end of the lease, beginning of the lease, in the middle of the lease, it's just an ordinary incident of business occupation. So even though you've moved out, you've relocated somewhere else, you're trading from somewhere else, you're not going to pay any rent, you've handed the keys over, you're still in occupation for that purpose.
It's a matter of business practicality.
Yeah.
You're not going to be able to stay until the bitter end. They should have handed in the keys on the last day. I think they were very fortunate in that case. And there was another case, which is in my notes actually, Sight and Sound and Books, which said the exact opposite, really. You've got to be in occupation for the 5 or 14 years immediately before the lease came to an end for the purpose of the act. I think LAW2023 is a way of arguing, trying to get somebody off the hook when they've made the mistake. And I think if you're entitled to compensation for disturbance, certainly double compensation, you retain some degree of occupation till the bitter end.
Yeah. Oh, I think, as I said earlier on, I'm not very much in favour of kind of little pantomimes and, the sort of pantomime of popping in there twice a day and picking up the post, or, keeping one person and a dog and a telephone in there. It's a bit daft, isn't it, really?
I think using for storage, fine. You don't have to have sort of person in occupation, using for storage and handing in the keys on the last day.
Yeah.
I think that's probably as far as it goes.
Yeah. Okay. Now here's one about my informal occupation session. And I was talking in that session about how informal sort of occupation may arise. And this question is, my client had just a sort of equitable assignment situation you described, where the prospective assignee was found to be in occupation some months down the line with no license to assign in place. We then found out they'd paid the last 3 rent installments, which the client had accepted. If they've paid the rent, is that enough to stop them from denying they've taken an assignment? Always tricky, these kind of situations. You get these things where an application for license to assign just kind of runs into the sand for whatever reason, and months down the line you find you've got somebody else there and they've been paying the rent and they are paying the rent, and the landlord may well think, okay, well, at least somebody's there paying the rent, I'll put up with it, and one of the difficulties you have is occupiers in that kind of situation play on the uncertainty, and they'll comply with whatever covenants they feel like complying with. But, as long as they want the property, they'll pay you rent, but hand them a schedule of dilapidations and watch their dust, in some ways, if you can establish an equitable assignment, that's quite a good outcome, in that it means they're liable on the terms of the lease. So at least you know what the basis of occupation is. But it is, I mean, as the question identifies, and I said in the session, is based on estoppel, really. The occupier must be stopped from denying that they've taken an assignment of the lease. And there's always, it's never going to be a slam dunk, because it's always a detailed factual inquiry, and paying the rent, last 3 rent installments, that's a sort of reasonably strong indicator. But then, you need to know more. Like, did they purport to do so on behalf of the named tenant, or was there anything to bring things to the landlord's attention? It's by no means clear by itself that the payment of rent for 3 installments is going to give rise to an equitable assignment. So I think there's a sort of limited answer to the question. No, it is not enough in isolation. You need to know an awful lot more about the factual background to make that kind of judgment. You come across these kind of situations, Richard?
Yeah. I mean, I suspect they probably happen a lot more than people imagine, quite honestly. Oh, and the other one is some sole trader tenant who incorporates without the landlord being aware of it. It's a similar kind of argument, really. You know, when does that company tenant suddenly become your actual tenant, at least in equity?
Yeah.
And it depends, I suspect, so much on the facts. You know, are you agents, like you mentioned, you know, sort of paying the rent as an agent for the other person or not? But I think it happens a lot, again, in the lower end of the market.
Yeah.
Not much else.
Yeah. And it's always worth sorting out, I think.
Yeah.
Landlords never want to spend the money, and they end up spending an awful lot of money because they spend 2 years going, well, just get the license to assign over the line and everything will be fine, and it never happens.
Yeah.
Anyway, so one for you. We're back to the 1954 Act. What duration of lease can a tenant insist upon on a 1954 Act renewal?
Well, it's the maximum duration is 15 years. Used to be 14 years. It was changed back in 2004 to 15 years to match modern rent reviews. I don't think many tenants, certainly in the retail sector, want 15 years at the moment. Outside that, if you read the textbooks, the consensus is that, well, the Court of Appeal decision in Betty's Cafe and Phillips Furnishing Stores, not the House of Lords decision, said that the tenant can't get longer than their existing lease, but with those provisos, the tenant gets what they're asking for, unless they're asking for a very short term. So the landlord has to start advertising and marketing almost immediately. And that's sort of the background to it. Actually, since I did the recording, there's been another reported case, only a county court case, which discusses how you might, if you've got development potential, sort of argue for perhaps not a shorter term than the tenant wants, but including a redevelopment break. Have you seen that B&M case?
Yeah.
The HSBC pension trust, which is a bit dubious, but they claim it's based on a case called National Car Parks in
That's right.
in Paternoster Consortium,
Yeah.
where it was the development of Paternoster Squares outside St. Paul's Cathedral. And St. Paul's Cathedral is a World Heritage Site, and like any World Heritage Site, it benefits greatly from having an NCP car park next door to it. I think it was underground car park, but they were wanting to develop Paternoster Square, and NCP successfully argued for a 10-year lease, a renewal, a 10-year lease. It was one day they're going to go ahead with the development, but the sort of public inquiries and the likes before they could do anything were going to last at least 2 years. So they successfully argued you can have a 10-year lease, but you can have a 2-year rolling break after development break after 2 years. This B&M case, I don't know what you think about it, bizarrely said you can have I think it was a 10-year lease, but you can have, the landlord can have a rolling break immediately. You can serve 6 months notice at any time.
It's a fairly it's a fairly harsh one on the tenant. That I wouldn't expect ever to see an outcome. Well, you should never say never, but I wouldn't expect to see an outcome in any case where the landlord gets a more favourable outcome than that. But I mean, I think that was coloured a little bit by the fact that the tenant was extraordinarily lucky and the landlord lost their Section 26 request in their mailroom, so lost the opportunity to oppose on ground F.
Blamed is on lockdown.
Yeah, so bulldozers revving at the site boundary, and keen to get on with it as soon as possible.
Some of the evidence seems to be that because they wanted to transfer to Aldi, from decrepit sort of 1970s garden centre or something, but they wanted to transfer to Aldi, but some of the evidence seems to suggest that the development wouldn't be ready until about 2028. So,
yeah, although I think there was a long stop date on the agreement for lease of 2025 or something. So that also probably influenced the decision. But I mean, the burden to get a break clause in a lease isn't hard. It's more a
Yeah,
question of what the term will be, as you say. How soon will you be able to exercise it? How much notice will you have to give?
I think they were lucky in that B&M case, but as I say, it wasn't in my notes. It was beginning of the spring, I think it was.
It wasn't long ago. Yeah.
But so yeah, the tenant usually gets what they're asking for, as long as they're asking for no longer than the original lease, less than 15 years or 15 years or less, and all the very short lease.
Although we had there's the Iceland and Castlebrook case, which is now going back, I suppose, about 10 years. I mean, there's Dukeminster and West End a bit more recently, where the courts have effectively split the difference. I said we should strike a balance between the two parties, and and those cases are a bit taking a bit of a different line from the traditional view. And
Yeah,
I kind of wondered if, following the pandemic and with everybody wanting flexibility in short term, whether the courts would row back from that a little bit. And there was a case just a couple of months ago where they seemed to. Was it the H Put case? I've forgotten now, but there has been a case recently where the court has not imposed a longer term than the tenant wanted. Essentially saying everybody wants flexibility. It's very important, you know.
yeah. You wonder about some of the first instance decisions, though. I mean, I know the vast majority of occasions they are first instance decisions, but you do wonder about, they don't always follow what the higher courts say that you should follow, really.
Sure.
Same with the 54 out renewals, really. Terms of renewal.
Yeah, exactly. I mean, we could really do some certainty on treatment of rent-free periods, on fixing the rent under Section 34. There's about half a dozen cases now going different ways, and until something gets to the Court of Appeal, we don't know where we are. So, all right, one for me. This might be almost the last one, depends how quickly we are. But why is it difficult to maintain a claim for double yearly value or double rent, which I touched on in the informal occupation talk? Surely, if the requirements of the statute are satisfied, the claim's a good one. Yes and no, but I mean, we are talking double yearly value is under the Landlord and Tenant Act of 1730, double rent under the Distress for Rent Act of 1737, I think it is. And they're both good, sort of, keeping the tenants in order sort of statutes. I think the preamble, I think it's the 1730 Act, calls it something like an act for the more effectual preventing of frauds committed by tenants. And quite right too. And the judges say these are penal statutes. They're reading together as a code. They're penal statutes, and therefore they interpret them strictly against the landlord as much as they can. It's pretty hard to make these claims stick. It's more of a good deterrent to kind of persuade it, to twist a tenant's arm and make them believe that if they don't go, they're going to end up paying a huge amount of money. And tenants won't know how difficult it is to make these claims stick. But I mean, if I can be forgiven an anecdote, I appeared in the High Court in front of a master of the High Court on a summary judgment application against a tenant. And we were going for possession and arrears and interest and mean profits and double value and all the rest of it. And we succeeded, and the master was pronouncing his judgment, and he said nothing about the double yearly value. And I said, "Excuse me, master, you haven't dealt with the claim for double yearly value." And he sort of glared at me and said, "I'm not giving you that. That Act of Parliament's 250 years old." And I said, "Well, I'm obliged to you, master. I didn't realize they ceased to apply after 250 years." And he said, "Well, there it is." So that was that. So it's not really a matter of interpreting the statute. He just wasn't going to give it to me. So that is a practical experience for how those claims might pan out.
Yeah,
but persuasive. They can be persuasive.
I like the idea of old statute. You can just ignore them. I might start sub-impudation again. But that won't mean much to some people. I think I agree. I've known it be a nice threat and a way of getting rid of tenants when you just threaten them with double compensation. But it's not that easy in practice. It acts as a good threat, I think, is the answer to it.
And I always think, in theory, and it will only ever be in theory, I suppose, but I don't know of any reason why, if you've got a tenant who remains in occupation after the end of the tenancy with no right to be there, that not only could you claim double yearly value or double rent, as the case may be, but also mean profits and effectively get triple rent. So, you know, but as I say, I don't suppose that's ever going to happen in practice. So,
No.
well, I think that is all we've got time for. So thank you everyone for watching Law 2023 Online Commercial Property Shape the Debate. Don't forget to join the solicitors group Law 2023 Online community on LinkedIn to continue the debate and to be included in exclusive offers for future events. If you've purchased the online course, there's still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. And for those of you that haven't, there's still time to buy the complete event, including a recording of this session. To book, just go to the solicitorsgroup.co.uk, where you'll also find the online exhibition. The exhibition is open for anyone to visit. And if you book the entire package, you can claim your free 1-hour CPD webinar from the webinar learning catalogue. That's worth £35 plus VAT. Finally, after viewing the online course, please complete the feedback form that's available in the related links section, and you'll receive your CPD certificate via email. But thank you again. Thank you, Richard. Always a pleasure to chat with you. And everybody have a good day. Thank you.
Okay, thanks. Bye.